This lecture will be devoted to on Protection of Human Rights Act 1993. In our previous lectures, under the playlists of human rights, in three important lengthy lectures, we have already discussed regarding the very meaning, nature, scope of human rights and also regarding the landmark judgments on human rights under the head Human Rights and Indian Judiciary in two parts. And in this particular lecture, we would like to discuss about the very act Protection of Human Rights Act 1993, which came into effect in 1994. So, regarding that, we would like to discuss first the introduction and background of human rights. So, the Constitution of India and also the Universal Declaration of Human Rights of 1948, the Civil and Political Covenant of 1966, the Social, Economic and Cultural Covenant of 1966. So, regarding that, the Constitution of India in Part 3, under the heading Fundamental Rights, provides a number of provisions on the protection and promotion of human rights in India. The Indian judiciary in the last 60 years since the implementation of the Constitution has played a vital role in safeguarding those rights through numerous decisions. In spite of all these the happenings in the state of Punjab, northeast of India, Jammu and Kashmir, and the Naxalized violence raised many eyebrows towards the government on the violation of human rights by state in the name of national integrity and sovereignty. A number of foreign countries and international agencies like the Amnesty International made allegations on the violation of human rights by the government. Some allegations were raised by the non-governmental organizations and the press at home. As India is a signatory to the Universal Declaration of Human Rights 1948 and to the Civil and Political Covenant and to the Social, Economic and Cultural Covenant of 1966, so these allegations were raised in international forums and organizations like the General Assembly of the United Nations Organization. To counter all these criticisms and allegations, the government ultimately decided to enact a separate law exclusively relating to human rights. After long deliberations with different people and groups, the Union Parliament enacted the Protection of Human Rights Act 1993, which came into effect from 1994. So, the Protection Human Rights Act 1993 is the direct outcome on the growing concern in the country and abroad about issues relating to human rights, changing social realities, the emerging trends in the nature of crime and violence, and the existing laws, procedures, and systems of administration of justice compel the government of India to enact such a piece of legislation to bring about greater accountability and transparency, and devising efficient, effective methods to counterattack the allegations made against it. So now we will discuss about the very act and its provisions. So the very act consists of 8 chapters and 43 sections. So chapter 1 with section 1 and 2 covers the title, extent, commencement and definitions, the very constitution and composition and organization of National Human Rights Commission is provided under Chapter 2 from Section 3 to 11, which relates to the very appointment and composition of the human rights, and in regards to that, we'd like to discuss that section 12 to 16 of chapter 2, which deals with the functions and powers of the commission. So, the procedure relating to inquiry is explained in chapter 4 from section 17 to 20, Constitution of State Human Rights Commissions, are provided under chapter 5 from section 21 to section 29, while section 30 and 31 of chapter 6 provide the establishment of the human rights courts and appointment of special public prosecutors. So, to sum up, the Act provides for the constitution of a National Human Rights Commission, state human rights commissions in states, and human rights courts for better protection of human rights on for matters which are incidental thereto or connected therewith. And particularly, Section 2D provides the very definitions of the Act, which defines human rights as in this particular act, unless the context otherwise requires, human rights mean the rights relating to life, liberty, equality, and dignity of the individual, guaranteed by the Constitution or embodied in the international covenants and enforced by courts in India. Besides this definition, the Act does not deal with the nature and characteristics of human rights. It was not provided any categorization and elaboration of different basic or fundamental rights of the individual, as the definition in section 2 and subsection D has covered the aspects relating to life, liberty, equality, and dignity of the individuals, and which are provided in length in Part 3 of the Constitution of India. So, their analysis is no more required, as already discussed in this provisions, previous chapters. So, in the context, present context, we will discuss chapter 2 to chapter 6, which cover the Constitution, powers, and functions of National Human Rights Commissions, State Human Rights Commissions, and the Human Rights Courts. So at present, we would like to discuss about the National Human Rights Commission. So, chapter 2 and chapter 3 and chapter 4 of the present act as the Protection of Human Rights Act 1993 deal with the National Human Rights Commission, and in particularly chapter 2 exclusively play out the modalities and formalities of the Constitution and formation of the Commission. So, section 3 to section 11 of the chapter provides in detail the appointment and conditions of appointment of the chairman and members, manners of removal, terms and conditions of service, and the tenure of office. Accordingly, the central government appointed Justice Ranganatha Mishra, a former Chief Justice of India, as chairperson of the first National Human Rights Commission in October 1993. So ultimately, the first National Human Rights Commission came into existence to fulfill the dreams sketched out in the particular act, that is Protection of Human Rights Act 1993. So in particularly section 3 of the act provides the constitution of the commission. As per the provisions, itself consists of a chairperson and members. The chairperson shall be a former Chief Justice of India and has two members. One shall either a sitting or retired Supreme Court judge, one either a sitting or retired Chief Justice of a High Court, two members having knowledge or practical experience in matters relating to human rights. Besides this, the chairpersons of the National Commission for Scheduled Caste and Scheduled Tribe, the National Women Commission, and the National Minorities Commission shall be deemed to be members of the Commission to discharge the day-to-day functions and power. There shall be a Secretary General who shall be the Chief Executive Officer of the Commission. The office of the Commission shall be at New Delhi and may establish offices at other places in India with prior approval of the Union Government. The procedure and manner of appointment of the chairperson and members are provided under Section 4 of the Act. Accordingly, the President of India appoints them by warrant under his hand and seal. While making any such appointment, the President shall obtain the recommendation of a committee consisting of the Prime Minister of India, the Speaker of the Lok Sabha or House of People, the Home Minister of the central government, the leader of opposition in the House of People or the Lok Sabha, the leader of opposition in Rajya Sabha or Council of States, and the deputy chairman of the Rajya Sabha. Further, in case of appointing any sitting judge of the Supreme Court or Chief Justice of a High Court, consultation with the Chief Justice of India is a must. And Section 5 of the Act says about the procedure and manner of removal of the chairperson or any other member of the commission. So the president can remove the chairperson or any other member only after receiving the report of inquiry of the Supreme Court to which a reference already made by the President in this regard on the grounds of proved misbehavior or incapacity. The President has also the power to remove without making any reference to the Supreme Court if the chairperson or any member of the commission is adjudged as an insolvent or engaged in any paid employment or found of infirmity of mind or body or of unsound mind or convicted for an offense of moral turpitude as to their terms and conditions of service. Section 8 of the Act lays down that neither the salary and allowances nor the other terms and conditions of service shall be varied to their disadvantage after their appointments, while Section 6 provides the tenure of their office. As such, the chairperson shall hold office for a period of 5 years or until he attains the age of 70 years. Members shall hold office for a term of 5 years or until he attains the age of 70 years, and members are eligible to be reappointed. The provisions of this section restricted or prohibited further employment of the chairperson and members under the Government of India or under any state government. The recruitment of other officers and staff for the commission is provided under Section 11 of the Act. The Union government shall make available an officer of the rank of Secretary to Government of India as Secretary General of the Commission for efficient functioning of the Commission. The central government shall provide such police and investigative staff required by the Commission. Besides these officers and staff, the Commission is also empowered under this section to appoint such other administrative, technical, and scientific staff as it may consider necessary. So now we would like to discuss about the very powers and functions as provided under Chapter 3 of the Act, in particularly under sections 12, 13, 14, and ultimately under section 18. So the functions and powers of the National Human Rights Commissions are embodied in Chapter 3 of the Act under section 12, 13, and 14 of the Act. The underlying provisions of section 12 entitle the Commission to perform the following functions, and they are: the Commission, on its own initiative or on the petition by a victim or any person on his behalf, has the power to inquire into any violation of human rights or abatement thereof and negligence in the prevention of such violation by a public servant. And second most important function falling under section 12, the Commission has the power to intervene in any proceedings involving any challenge or allegation of violation of human rights pending before a court. And the third important function, the Commission can visit any jail or institution where persons are detained under the state government control this to study the living conditions of the inmates and make necessary recommendations thereon. And the fourth important function is that the Commission shall encourage the efforts of non-governmental organizations and institutions working in the field of human rights. And the fifth important function is that the function of the Commission to increase awareness and consciousness among the people regarding the safeguards provided through human rights, literacy missions, publications, the media, seminars, and other available means. And the next important function that it has the power to review the safeguards provided in the Constitution of India and in any other law regarding human rights and suggest measures for their effective implementation. And the seventh important function is that it shall also has the power to review factors like terrorism, Naxalism, and other related issues affecting human rights and suggest appropriate remedial measures. And the eighth important function, the Commission has also the power to study international treaties, conventions, protocols, and instruments relating to human rights and suggest for their effective implementation. And the ninth important function of the Commission, it shall also undertake and promote research activities in the field of human rights. And finally, the last important function, it can perform such other functions as it may consider necessary for the protection and promotion of human rights. And now we will go to examine the provisions of Section 13 relating to the very function of the National Human Rights Commission. So, under subsection 1 of Section 13 of the Act deals with powers relating to inquiries, and while doing such, the Commission shall have the power of a civil court as provided under Order 16 in Civil Procedure Code of 1908. As such, it has the power of summoning and enforcing the attendance of witnesses and examining them on oath, and also regarding discovery and production of any document, receiving evidence on affidavits, and call for any public record or copy from any court or office. And as regarding issuing commissions for the examination of witnesses or documents, while Order 11 deals with discovery and inspection, Order 19 deals with affidavits, and Order 26 of the Civil Procedure Code deals with commissions, while subsection 2 of section 13 empowered the Commission to receive any information required in subject matter of inquiry, and the person from whom such information required is bound to furnish such information as per the provisions of section 176 and 177 of Indian Penal Code. In the process of inquiry, the Commission under subsection 3 has the power to enter any place or building and can seize any document or copies from such place subject to the provisions of section 100 of the Code of Criminal Procedure 1973, while subsection 4 of Section 13 says that any offense falling under the sections such as Section 175, 178, 179, Section 180, or Section 228 of Indian Penal Code, if committed in the view or presence of the Commission has the power to forward such case to a magistrate for hearing as per the provisions of Section 346 of the Criminal Procedure Code. Every proceeding before the Commission shall be deemed to be a judicial proceedings within the meaning of Section 193 and Section 228, and for the very purposes of Section 196 of Indian Penal Code, and shall be deemed to be a civil code for all the purposes of Section 195 of the Criminal Procedure Code as provided under subsection 5 of Section 13 of the Protection of Human Rights Act 1993 for the purpose of conducting investigation. The Commission can utilize the services of any officer or any investigative agency of either the central or state government with prior permission, and for such utilization under Section 14 of the Act, for such investigation it can summon or enforce attendance of any person and examine him, require the discovery and production of any document or requisition of any public record or copy thereof from any office, the officer or agency so utilized shall submit a report of the investigation before the Commission within a time frame as decided by the Commission. Further, under this section, the Commission can also make inquiry and examination of such person or persons who conducted or assisted in such investigation to ascertain about the correctness of the fact stated in the report. And now we would examine the important provisions under Section 18 relating to the powers and functions of the National Human Rights Commission. At last, the Commission, after completing the inquiry, recommend to the appropriate government or authority to take action against the person concerned, where the inquiry discloses the violation of human rights as it is provided under subsection 1 of Section 18. It may also recommend the government or authority for grant of necessary interim relief to the victim or his family members as per subsection 2 of Section 18 of the Protection of Human Rights Act 1993. The Commission may approve the Supreme Court or the concerned High Court to pass such directions and rates as that court may deem necessary as provided under subsection 3 of Section 18. Besides this, the Commission has also the power to provide a copy of inquiry report to the petitioner and shall also send the same with its recommendations to the concerned government or authority. Finally, the National Human Rights Commission shall publish its inquiry report together with the action taken or proposed to be taken by the concerned government or the authority on the recommendations of the Commission. And now we would like to discuss regarding state human rights commissions, their constitution and composition under section 21, and in that connection list 2 and list 3, which consists the state list and the concurrent list under the 7th schedule of the Constitution, and the very appointment of the chairman and members of the State Human Rights Commission and their removal as provided under section 23, and the terms and conditions of the tenures under section 24, section 26 and 27. So now we would like to discuss about the State Human Rights Commissions. The constitution of the State Human Rights Commissions almost same in comparison to National Human Rights Commission as per the provisions of subsection 1, subsection 2 and subsection 3 and subsection 4 of section 21 of the Act. While the chairperson shall be a retired Chief Justice of a High Court, the member shall be either sitting or retired Judge of a High Court, a sitting or retired district judge, and two persons having knowledge or practical experience in matters relating to human rights. Next, there shall be a secretary who shall be the chief executive officer of the commission. So, subsection 5 of section 21 limited the jurisdiction of the commission regarding its power of inquiry and investigation. According, it may only inquiry into violation of human rights in respects of those matters falling under the entries enumerated in list 2, that is the state list, and list 3rd, that is the concurrent list in the 7th schedule to the Constitution of India, while section 22 prescribes the procedure of appointment of the chairperson and other members on the recommendation of a committee consisting the chief minister of the state, the speaker of the state legislative assembly, the minister in charge of homes, and the leader of opposition, and the governor of the state, who appoints by warrant under his hand and seal. And regarding removal of the chairperson and members, section 23 of the Act spells out that the President, after receiving the report of the Supreme Court to his already reference met in that respect on the grounds of proved misbehavior or incapacity, has necessary powers in this regard. He may also remove the chairperson or any member without a reference to the Supreme Court on the grounds of insolvency or engaged in any paid employment or infirmity of mind or body or of unsound mind, or is convicted of moral turpitude. As to their terms and conditions of service under section 26 to their terms of office under Section 24 and officers and staff as under Section 27 are more similar as to the provisions regarding National Human Rights Commission. As already we have discussed about that under Section 6 and Section 8 and Section 11 of the Act. And now we would like to discuss about another important provision of the Act relating to human rights courts, which is provided under Chapter 6 under Section 30. So, in relating to that Section 30 of the Protection of Human Rights Act 1993, under Chapter 6 provides for the establishment and constitution of human rights courts for the purpose of providing speedy trial of offences arising out of violation of human rights. The state government, with consultation of the Chief Justice of the High Court, may specify for each district a court of session or the district sessions court to be a human rights court to try such offences, and provisions of this section shall not hamper if a special court is already constituted for trial of such offences. For every such human rights court, the state government shall appoint public prosecutor or an advocate who has been in practice for not less than 7 years for the purpose of conducting cases in the human rights court. Such a person shall be called a special public prosecutor as provided under the very provisions of Section 31 of the Act. As Section 30 deals with not only lay down the jurisdiction and procedures to be followed by such courts, so questions arise as to what cases shall be decided by such courts and what should be the precise nature of the offences that should be tried in such courts. In light of the above ambiguity, the National Human Rights Commission recommended to the central government for substantive amendment to Section 30 for speedy trial of offences arising out of violation of human rights. So these courts cannot serve any fruitful purpose until a comprehensive legislation is passed specifying that what offences are classified as human rights offences. And before closing the very discussion on the Protection of Human Rights Act 1993, we would like to end with a conclusion. So the lecture on human rights will remain incomplete without a reference to John Winston Lenon, the famous Beatle who was a great humanist, and his humanistic poem, Imagine, left a lasting impact on the mankind and is the official song of the Amnesty International, whose head office is at London, which the international organization fighting for the cause of human rights since 1961, the year of its establishment by the British lawyer Peter Berenson. So, we would like to conclude with the humanistic poem by John Winston Lenon, the famous Beatle. So imagine there's no heaven. It's easy if you try. No hell below us. Above us only sky. Imagine all the people living for today. Imagine there's no countries. It is not hard to do. Nothing to kill or die for. No religion too. Imagine all the people living life in peace. Imagine no possessions. I wonder if you can. No need for greed or hunger. A brotherhood of man. Imagine all the people sharing all the world. You may say, I am a dreamer, but I am not the only one. I hope someday you all join us and the world will live as one. The magic of these 22 lines of the poem Imagine written by the great famous Beatle John Winston Lenon is of graceful, plain spoken faith in the power of a world united in imagination and purpose to repair and change itself.